Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Alex Ferri and Luke Tompkins, North Carolina's construction lien law experts. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Alex Ferri and Luke Tompkins.
Thank you, Jessie. We appreciate the opportunity to be here. Luke and I are both construction litigators here at Warden Smith in North Carolina, and we're happy to speak with you guys today about these lien basics and bond basics. We think it'll be pretty helpful. This is just the tip of the iceberg with lien law, but we think it'll give you a good primer on what's going on. So I want to just go through real quick some housekeeping. If you have questions during this webinar, if you'll go to the webinar chat box on the right of your screen, you can type in your questions there. And then at the end of the presentation, we'll go through the questions and answer any questions that you guys have. We ask that you not include any names or company names in the questions. Just keep them as generic as possible so that we can help you the best that we can. So this is our agenda that we're going to go through. We'll start with some preliminary considerations when it comes to just contracting in general, whether you're a GC, a sub, or a supplier, specifically as it relates to ensuring your right to payment later in the project if some problem arises. Then we'll talk about the liens that are available to GCs specifically, and then the liens available to subs and suppliers specifically. They're not always the same in North Carolina. And then we will go to federal and state projects. So we'll talk about how to recover under bonds on federal and then how to recover under a bond on state projects. So first, these preliminary considerations. What should you be thinking about at the start of the project or before the project even begins so that later on you can protect your right to payment? The first, just general one is looking at your contract and deciding whether you think it's up to date. So I know that a lot of companies will use their own contract and they'll use it for years and years, and it tends to serve them well for a long time. But the law changes, and it's important to look at your contract regularly, make sure that it's still up to date. Is your standard contract applicable to each job? Are you covering yourself in all the ways that you should for all of the specific situations that might come up on some jobs and not on others? Is there anything you need to add to your standard contract for some jobs in particular? And then, has an attorney looked at your contract recently? If you've had the same standard contract for a long time, maybe it's worth having someone else put their eyes on it. They can go through and see if there's anything you're missing that you can incorporate one time and then use for years to come in that same standard contract. As it relates to lien rights specifically, there are a few contract clauses that you want to look out for. One of them is a contract clause saying that the GC or the sub waives all lien rights. Those are void and unenforceable in North Carolina. So if you enter into a contract that has a clause saying you have no lien rights, just from the beginning of the project, no matter what happens, right here, right now, you're waiving all right to assert a lien in the future, void and unenforceable. There are some variations of that are allowed. So if a clause says that a GC or sub has to subordinate its lien rights to an owner or an owner's lender, that is allowed. Or if there's a clause that you waive your lien rights upon payment, you have to assign partial lien waivers. Those are also allowed. The difference between a partial lien waiver and a clause waiving all lien rights is with a partial lien waiver, you're only waiving your lien right after you've been paid. That is permitted. One important caveat there, though, is that you may still have certain lien rights even after executing a partial lien waiver. So if you're owed a lot of money and you think that you have no recourse because you've signed a partial lien waiver, it might be worth looking into Whether there are some lien rights that you've got that you didn't waive with those lien waivers that you signed. And Luke, I think, is going to talk about some notices.
Yeah, hey, good afternoon, everyone. As Alex said, my name is Luke Tompkins. I'm also a construction attorney with Warden Smith. Just a few, again, preliminary considerations here. One thing to consider when you are working on a construction project is the role of lien agents. And then there's a mechanism in North Carolina called a notice of contract. So I'm going to go over those two things with you all briefly. First, on all commercial projects and some residential projects in North Carolina, the owner is required to appoint a lien agent. And the role of the lien agent is really for any contractors and subcontractors who are working on the project to give notice that they are doing work on the project, and that, you know, essentially to notify the owner, hey, you know, we're working on the project, and, you know, if we don't get paid, we will have the right to exercise our lien rights. And so once you get involved on a project in North Carolina, one of the first things that you should do, there's a website called liensnc.com. If you don't already have an account there, I highly advise that you create one. But one of the first things you should do is go on liensnc.com, look up the project by the name of the owner or the address of the project, and go ahead and submit a notice to the lien agent that you're going to be a subcontractor on that project. And what that does is it puts you in line so that if you ever do file a lien, your lien will relate back to the date of first furnishing of labor or materials on the project. If you do not provide that notice to the lien agent, then you're going to be in line behind others who may have lien claims and who did go through that notice to the lien agent process. So that is one of the things that you can do at the outset of the project to preserve your lien rights, to put yourself in the best position to recover the payments that you're due if a dispute does arise on a project and if you're not getting paid timely. And you want to provide that notice really as soon as you get involved on the project. The best thing to do, as I said, is just practically is to go ahead to the Liens NC, and you can submit your notice to the lien agent through there. Next, on the notice of contract mechanism. So general contractors on projects in North Carolina have a mechanism where within 30 days of the issuance of the building permit, or 30 days after the date the contract is awarded to them by the owner, they can post a document known as a notice of contract. And if you look this up, you'd be able to find one pretty easily. But you post that on the project site and you file it with the clerk of court in the county where the project is located. And what that does is it puts the onus on any subcontractors that they have to then provide and serve on the GC a notice of subcontract to have any right to a subrogation lien on the property. And so by doing this, it puts the ball in the subcontractor's court, and it gives the contractor, a GC, a pretty good tool to try to avoid an issue where they might have to pay twice for the same work because of liens that are filed. So again, this is something everyone that works as a general contractor should consider at the outset of the project, is going ahead and taking advantage of that notice of contract process so that you can protect yourself and also the owner, and hopefully, you know, have less lien issues later on in the project. Now, if you're a subcontractor and the GC has posted that notice of contract, then you will need to provide a notice of subcontract to the GC, which will then preserve your lien rights. So something for both general contractors and subcontractors to be aware of there. And then let's see.
I'm going to go into liens now, Luke, if you're finished with that. So we'll talk about bonds later on, but liens in North Carolina, you're only permitted to assert a lien on private projects. So if you're working on a public project, if it's federal or state, you're not going to have these lien rights that we're going to go through real quick, but we'll get to what you can do on federal and state projects in just a little bit. So first, the liens that are available to general contractors. And when we say general contractor, GC, in this presentation, we're talking about the entity that contracts directly with the owner. So to a lot of people, that's the prime contractor. In the lien statutes, they're just called the contractor, but that's who we're talking about, an entity or a person that has a contract directly with the owner. And the GC's lien rights are through a lien on real property. Some subcontractors and suppliers in certain circumstances can also assert a lien on real property. We will talk about that in a minute, but this is really sort of meant for GCs. If you are owed money as a GC, this is the lien that you're going to assert. And the way that it works is it attaches to the actual property and it clouds the title on the property. It attaches when you file and serve a claim of lien on real property, and those you have to include specific things in your claim of lien on real property. They're statutorily defined, but it has to be done within 120 days of the last date of furnishing. So the last date that you provided labor or materials, things like that, to the project, 120 days from there. If you want to assert a lien, you've got to file and serve your claim of lien on real property. One important thing to note about a lien on real property is it can't be amended. So if you have ever been involved in litigation at all, you initiate litigation by filing a complaint, and those regularly get amended later on as facts change and you learn more things. That's not uncommon. There are other legal documents that you can amend after filing, and it doesn't necessarily affect the date that you filed it, but with a lien on real property, it cannot be amended. So if you assert a lien, you file it on day 119 after your last date of furnishing, and on day 121 you realize, oh, I left off $10,000 from my lien on real property, you're now outside the 120-day window. The only way for you to fix it would be to discharge the lien and refile it, start from scratch. But now you're at day 121, you're outside that 120-day window, you can't refile it. So it's important when you assert a lien on real property that you get it right the first time, or as close as you can, because that's what you're going to be stuck with if you don't have time to discharge and refile within that 120-day period. And then it is perfected by filing a lawsuit to foreclose the claim of lien on real property. That has to be done within 180 days of the last date of furnishing. So you've got your last date of furnishing, you've got to file and serve the claim of lien on real property within 120 days, and then 60 days later, you've got to make sure that your lawsuit to foreclose that claim of lien on real property has been filed.
And I'll now talk about the liens that are available to subcontractors and suppliers, and that's principally the lien on funds and also the subrogated lien on real property. But we'll start with the lien on funds. And a lien on funds, what it is, it's a lien that's placed and attaches to the funds that are owed, any funds that are owed from the owner to the general contractor, or if it's a lower tier, if you're in the position of a second tier sub, it would be any funds that are owed from the first, or from the general contractor to the first tier. And so what it does as a practical matter is it puts the owner on notice that funds are not being passed down. So if you're a first tier sub and you file a notice of lien on funds or serve a notice of lien on funds, it's not filed. But if you serve it on the general contractor and on the owner, it puts the owner on notice that payments are not getting passed down to you. The owner then has to retain funds in the amount of your lien claim, and if it pays over that lien on funds, it becomes personally responsible to you as the second tier sub for the amount of your lien. So it puts the owner in a position where, from a practical perspective, they're going to be going to the general contractor and saying, hey, why am I receiving this lien on funds? And it also requires that they retain funds and that those don't get passed down to the general contractor. And when that occurs, what it really does from a practical perspective is that it encourages the folks that are involved on the project to come together and figure out a solution. And one of those practical solutions that you often see in these situations is what's called a joint check agreement, which is where the owner, for example, would pay any amount due to the general contractor by a joint check that also lists, if it was the first tier sub who filed the lien, list them as a payee, so that has to be passed along to the first tier. The owner doesn't have to worry about those funds not making it down to them. But it is a very valuable resource to subcontractors. And one of the important things with liens on funds is that you need to assert them as soon as it's clear that you've not been timely paid for work, because the lien only attaches to funds that have not been paid from the owner or from the higher tier contractor down to the person whom you're contracting with. And if they've been fully paid, it has no value. So the lien on funds is, again, it can be really helpful in preserving your payment rights, but it's one that you need to assert as soon as it becomes clear that you haven't been paid. It attaches to funds upon your first furnishing of labor or materials. The lien upon funds is perfected by service of the lien, and you'll be serving whomever you've contracted with. And if you're a lower tier sub, also you need to serve it on all higher tiers and on the owner to make sure everyone is provided notice of it. And there's no time limitation on it, but again, if you don't get it in timely, it's going to lose its value, because if other folks get paid out and you haven't already served that lien, then it's not going to be of any value. And I will let Alex speak about the subrogated lien on real property.
Thank you. So, like I said before, the lien on real property is primarily for GCs, but there are a couple ways that it can become available to subs and suppliers. The first is, like Luke was saying, with the lien on funds, the owner is required to maintain those funds that are subject of the lien on funds. If the owner pays over the lien on funds and doesn't retain that money, the benefit that you get as a sub or supplier is you now have the right to assert a lien on real property, which you otherwise wouldn't have. So it protects you. If the owner doesn't do what they're supposed to do, you get a new lien that you get to assert, a new kind of lien. And then the second is a subrogated lien on real property through the GC. So in this circumstance, you're essentially stepping into the GC's shoes and enforcing any lien rights that the GC has. Now that means that if the GC doesn't have any lien rights, if the GC has been fully paid out, then the GC can't assert a lien on real property. So you can't assert a subrogated lien on real property. Just think of it as I'm becoming the GC for the day, and whatever lien rights the GC has, that's what I'm going to assert through this subrogated lien. The subrogated lien on property is only available to first, second, and third tier subs and suppliers. So fourth tier and down, it's not an option in North Carolina. And again, what you're looking at here is whether the owner still owes the GC any money. Another interesting thing about a subrogated lien on real property, normally you're looking at 120 days and 180 days, again, for from your last date of furnishing to determine when you need to file the claim of lien, and then when you need to perfect it, file the lawsuit to perfect it. With a subrogated lien on real property, remember you're stepping into the owner's shoes. You can use your own last date of furnishing, or you can use the GC's last date of furnishing, which in a lot of situations is going to be later than a subs or supplier. So you really do have some more options with that subrogated lien on real property, and it's a great tool if it's available to you.
All right. Next, we are going to discuss payment bonds on state or federal government projects. And so just from a general background, when you've got a government project, the general contractor, as long as the project is over a certain amount, is going to be required to get a surety to supply a payment bond that acts as the security for lower tier contractors' payment rights on the project. And so we'll go over when payment bonds are available, who it's available to, the timing of submitting claims against those payment bonds. But that's just some background on what they are. So on federal projects, payment bonds are required from the GC and available to lower subs when the general contractor's contract is for more than $100,000. And the right to make a claim on the payment bond is available to first tier subcontractors, second tier subcontractors, first tier suppliers, and second tier suppliers, but only if they supply materials to the first tier sub. So if you're a second tier material supplier and you supply materials to a first tier material supplier, you actually would not have a right to make a claim against the payment bond. From a timing perspective, on federal projects, a first tier subcontractor, because they have a contract with the general contractor, they have no notice requirement to provide notice to the GC that they intend to make a claim on the payment bond, because the GC is already aware of them because they have a direct contract with them. And for first tier subs, you do have to wait 90 days to file an action to enforce a payment bond claim, because if payment is made within 90 days, that's technically timely under the payment bond statute. For second tier subs, there is a requirement to provide written notice of a claim on a payment bond to the general contractor within 90 days of your date of last furnishing. So, you've got to set a clock on that, and if you haven't been paid, you need to just go ahead and notify the GC. And usually it's a good practice to notify the payment bond surety. That's a company who is providing the security bond to secure your payment rights. Go ahead and notify them that you haven't been paid, and that if you're not paid, you're going to exercise your rights to submit a bond claim against the payment bond. And then finally, with respect to the time for filing an action, the action has to be filed after 90 days, but within 1 year of your last date of furnishing of labor or materials to the project.
And then our last topic, I'm going to talk about payment bonds on public North Carolina projects instead of federal. So these are available on projects where a North Carolina governmental or public body is the owner. The total contracts awarded exceed $300,000, and the GC's contract is $50,000 or more. So you got a North Carolina government owner, total contracts greater than 300,000, GC's contract 50,000 or more. If that's the case, then there's got to be a payment bond. These claims on payment bonds are available to any sub, any supplier at any level. So those restrictions that the federal bonds have don't have that in North Carolina. Any tier is good to file a claim on a payment bond. As far as timing, you've got some initial notices that a second tier subcontractor and anyone below second tier is required to provide a written notice of public subcontract, and that goes up the contractual chain to the GC. If you don't do this, you can still file a claim on the payment bond, but your recovery will be limited to $20,000. There's not really a time limit to do this, but there is an incentive to serve it as early as possible, because the statute says that a bond claim shall not include labor or materials provided more than 75 days before the notice of public subcontract is served. So if you have been working on the project for 200 days, you start to think, this looks like I'm not going to get paid. Maybe I should go ahead and serve this notice of public subcontract so that I can make a claim on the payment bond. You're 200 days in. You cannot make a claim for any money owed for the work you did the first 125 days of the project. You're limited to that 75 days before you filed or you served this notice. So there's no time limit, but do it as soon as you can. Even if you don't think there's going to be any payment issues, you just don't know. The next is the notice of the actual claim. So if you're a first tier subcontractor, you do not have to give any notice of your claim. But if you're a second tier sub or lower, you have to provide a written notice of the claim on the bond to the GC within 120 days of your date of last furnishing. And then to file an action to enforce your claim, both the first tier and second tier and beyond have to wait 90 days from the last date of furnishing, and then no later than the longer of 1 year after your last date of furnishing, or 1 year from the date when a settlement is reached between the GC and owner. So just like on federal projects, you've got to wait 90 days, no matter who you are, no matter if you had to file that notice of claim, which first tier subs don't have to. You still have to wait those 90 days. And then you can't wait longer than 1 year or the date after a settlement is reached between the GC and owner. We're turning it back over to Jesse now if anybody put any questions in the chat.
Well, first of all, Alex and Luke, you guys were incredible. That was a lot of information that you did cram pack into the last 20 minutes or so. So thank you so much for that. We do have a couple of questions that came through. So I'm going to go ahead and read them off to you guys. The first one, it says, do I have to be licensed in North Carolina to have lien rights?
That's a great question. First and foremost, if you are doing work in excess of $30,000 on a project in North Carolina, generally you're required to be licensed. And if you're not, your contract to do that work can be deemed invalid. And so if that's the case, you're not going to have lien rights. So generally, if you're working on a North Carolina project and there's more than $30,000 at issue, you need to have a license, or if you don't have a license, then you need to be working underneath someone who does. So someone else who has a license needs to be supervising your work. If in that second case, then I believe you'd still be fine with respect to lien rights.
Okay, perfect. Thank you so much. Okay, and then it says, can attorney's fees or filing fees be included into your lien amount?
So attorney's fees and filing fees typically are not, and Luke, correct me if I'm wrong, are not included in the lien amount that you actually put in your lien. But if you have a contract that has a clause that says that you're entitled to attorney's fees and the situation that applies to the situation at hand, then when you enforce the lien, that's when you would ask for those attorney's fees as part of the enforcement lawsuit. But for a lien, when you're asserting the actual lien, the only amount that you can put there is an amount that covers the work that you have performed, and attorney's fees and filing fees wouldn't be considered work that you've performed.
Perfect. They would be collected, I guess, during that lawsuit ensue. Okay, awesome. And then another question that came through, and bear with me, it's kind of a wordy one. As a first tier sub, is a notice of public subcontract required to be sent within the 75 days from your first day on a federal job before you can have a claim on the bond?
That's a great question. My first response is, provide that notice sort of early and often, and make sure that that folks are aware of your presence on the project. So we're talking about a public project. You're incentivized to make sure that that you get that notice in. Let's see. And bear with me for a second, because I'm just reviewing.
That's fine. Thank you. I appreciate you double checking and following up with it. I think the importance is making sure that you are sending notices, that people are aware that you are working on those jobs, following any kind of deadlines and meeting those well be within your time frame. You don't want to find yourself in a lurch.
That's absolutely right. And so that's really the takeaway there is, as soon as it becomes clear that you've got a claim, you want to make sure that you provide notice. And Alex, did you have anything to add on that?
Sorry, I had to unmute myself. I don't think that you have to on federal projects. The Miller Act is what applies to federal projects, and I don't think that there is a requirement in the Miller Act like there is in the Little Miller Act, which is North Carolina's version, for second tier and beyond to provide a notice of public subcontract. My understanding is that's specific to state projects. I would have to look into the Miller Act a little further just to be sure of that, but it's not a requirement that I'm aware of.
As far as my knowledge, for a federal job, know that the notice of public subcontractor is not required, but it is recommended always to send something along those lines. But I agree, I don't think that it's a requirement. All right, that is all of the questions that I have seen come through. If there is anybody that does have a question that wasn't addressed, please feel free to reach out. I will be sure to do my best to answer any questions as soon as possible for you. Can you go to the next slide for me, please, Alex? All right, perfect. All right, who is ready to win a gift? We're going to be testing your knowledge. If you guys can go ahead and take a look at these questions, if you want to chime in the questions or chat box and put your answers in there. If you're correct, we'll go ahead and send you guys over a little gift from SunRay. The first question is, when is the deadline to file a claim of lien on real property in North Carolina? And then the next question is, when is the deadline to file a lawsuit to foreclose a claim on lien on real property in North Carolina? I know Alex and Luke went over this information in this presentation, so if you were paying attention and listening, go ahead and chime in for us, and I will send you guys over a little gift from us. Alex, can you go ahead and go to the next slide for me? All right, here are some of the SunRay resources available to you guys to help have you guys stay organized, know your deadlines, secure your lien rights. So go ahead and scan this QR code. You'll be able to access all of these resources. On our website, we have a state lien law rules. So if you're working in a state that you're not familiar with, or you've got a new job coming up and it's in a neighboring state, click on that. You can kind of check it out. It will tell you what documents are needed, what the deadlines are, and be able to kind of help you stay organized and make sure that you guys are protecting yourself. So go ahead and scan that QR code to be able to access all of this. Go ahead and go to the next slide for me, please. All right, SunRay is offering a new service here. We have our SR receivables. We're going to help you guys handle your collections. So if you're not getting paid, give us a call. We will see what we can do to help get you guys paid. Give it, send us an email, call us, and we will give you more information. The next slide, please. All right, our next webinar with Alex and Luke about North Carolina's lien law is going to be Don't Sign a Release Unless It Says This One Thing. That's October 10th at 12 p.m. Eastern. So go ahead and sign up for free. It's sunraynotice.com/education. We'd love to see you there. Next slide, please. All right, if you don't mind, take a moment to review us on Google. We'd really appreciate it. It only takes about a minute of your time, but it helps us get the feedback and better our webinars, as well as make sure this material is reaching more contractors and suppliers like yourselves. The next slide, please. And with that, that is all we have for you guys today. Thank you so much for everybody who did attend. We hope to see you at our next webinar. Thank you again, Alex and Luke. You guys really were sensational. I appreciate all of your time and answering all those questions for us. And I hope you all have a wonderful and beautiful sunny day. Thanks again, everyone.